At the Nuremberg Doctors Trial, lawyers defending Nazi physicians cited an American Supreme Court decision, not as background, but as precedent. The case was Buck versus Bell. In 1927, the U.S. Supreme Court upheld the forced sterilization of a young woman named Carrie Buck by a vote of 8-1. That ruling has never been expressly overturned. And Carrie Buck was told the surgery was for her appendix. I wasn't looking for this case. I was following a thread from an earlier documentary about the lobotomy epidemic, a pattern that kept appearing underneath American institutional medicine, the belief that certain people were genetically unworthy of reproduction and that the state had the obligation, not just the right, to enforce that judgment. Every time I pulled that thread, it led here. Before I get to what happened to Carrie, something needs to be established, because without it, the story is smaller than it actually is. This was not a conspiracy. It was a policy, debated openly in legislative chambers, written into law across 36 states, funded by research universities, endorsed 8-1 by the Supreme Court. A hidden crime is a moral failure. An official policy is a structural one, and those require different kinds of reckoning. Indiana passed one of the first modern compulsory sterilization laws in 1907, before the First World War, before Prohibition, before the word genetics was widely used in newspapers. The target? Individuals in state custody deemed mentally defective, feeble-minded, or criminal. By the 1920s, more than 24 states had passed similar laws. One of the most influential figures behind them was Harry Laughlin of the Eugenics Record Office, whose 1922 model statute helped standardize who the state could label unfit. The categories he listed included the feeble-minded, the insane, the criminalistic, and, this word is doing a great deal of work, the dependent. Anyone who could not support themselves economically. Not a medical diagnosis, an economic status. If that category had applied to you, if you had been poor enough or in the wrong institution at the wrong time, your name could have appeared on that list. Laughlin's model was cited in congressional hearings and legislative debates across the country. It was explicitly studied by the drafters of Nazi Germany's Law for the Prevention of Genetically Diseased Offspring in 1933. That relationship is well documented in the historical literature. In 1936, Harry Laughlin received an honorary doctorate from Heidelberg University in recognition of his contribution to racial science. And all of that still needed one thing the law could point to: a body. To make a law like that permanent, the state needed more than ideology. It needed a case the courts could bless. Her name was Carrie Buck. Carrie was born in Charlottesville, Virginia in 1906. Her mother Emma was poor and had been institutionalized as feeble-minded. As a small child, Carrie was placed with a foster family, the Dobbs. She attended school. Her teachers described her as an average student. Ordinary. She helped around the house. She grew up. In 1923, when Carrie was 17, a nephew of the Dobbs family raped her. She became pregnant. The Dobbs family, to conceal the scandal, had Carrie committed to the Virginia State Colony for Epileptics and Feeble-Minded. The reason listed in her commitment papers: feeble-mindedness and moral delinquency. She had been raped. She was committed to protect her attacker's reputation. Her daughter, Vivian, was born and taken from her immediately, placed, with some irony, back with the Dobbs family. What happened in court is what turns this from cruelty into design. Carrie Buck did have a lawyer. His name was Irving Whitehead. He was appointed to represent her. And Whitehead presented almost no defense. He called no witnesses who could speak to Carrie's actual intelligence. He did not challenge how Vivian had been assessed. He did not mention in any proceeding that Carrie's pregnancy was the result of rape. Irving Whitehead was a former member of the board of directors of the Virginia colony, the same institution seeking to sterilize his client. He was a personal associate of the officials who needed this case to succeed. His defense was not designed to protect Carrie Buck. It was designed to create a clean legal record so the law could stand. The case moved to the Supreme Court. On May 2, 1927, the Supreme Court ruled 8-1 in favor of the state of Virginia. The majority opinion was written by Justice Oliver Wendell Holmes, widely regarded as one of the most influential legal thinkers of his era. A Civil War veteran, a Harvard law professor, a man whose opinions shaped American jurisprudence for decades. His opinion in Buck v. Bell is 11 pages long. Near the end, he wrote, "It is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind." The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. And then, 3 generations of imbeciles are enough. Those words remain in the official record of the United States Supreme Court, unmodified. The 3 generations Holmes referred to were Emma, Carrie, and Vivian. Vivian Buck was 8 months old when the state of Virginia declared her feeble-minded. The assessment was conducted by a Red Cross nurse named Caroline Wilhelm, who testified that Vivian had a look about her, that she did not quite look normal. That was the evidence. A look about her on an 8-month-old infant. What happened to Carrie was brutal. What happened to her daughter is even harder to explain away. In April 1931, Vivian Buck, raised by the Dobbs family under the name Vivian Dobbs, made the honor roll at Venable Public Elementary School in Charlottesville. In September 1932, she died of an intestinal infection. She was 8 years old. The Supreme Court had written that 3 generations of imbeciles were enough. The child they labeled at 8 months old had made the honor roll. She died before she was old enough to testify to her own existence. The most disorienting thing about researching this case is not the injustice done to Carrie Buck. It is the ordinariness of it. Oliver Wendell Holmes was speaking from within a scientific and legal consensus that held extraordinary authority in his time. Albert Priddy ran the colony not as a rogue institution, but as a lawful one following a lawful statute. Irving Whitehead did not technically violate the rules of his profession. What he did was permitted. The machine did not malfunction. It worked exactly as built. That is the thing that does not get easier to look at. If you think this ended with World War II, it didn't. Between 1927 and the late 1970s, sterilization programs in 32 states resulted in the forced sterilization of approximately 60,000 Americans. But 60,000 is a number. Let me give it a face. Elaine Riddick was 13 years old in 1968 when she was sterilized by the North Carolina Eugenics Board after being raped by a neighbor and becoming pregnant. A 5-member board reviewed her case. They declared her feeble-minded and unfit. Her grandmother, who could not read, was asked to sign the consent form. Elaine Riddick did not learn she had been sterilized until she was 19 and trying to start a family. North Carolina's Eugenics Board remained active until 1974. The last confirmed sterilization under a state eugenics law in the United States took place in Oregon in 1981. 1981. The year MTV launched. The year Raiders of the Lost Ark opened in theaters. That year, in a state institution in Oregon, someone was sterilized without meaningful consent, under a law that traced its lineage directly through Buck versus Bell, through Laughlin's model statute, through the same current that ran from Indiana in 1907. Now for the Nuremberg connection. And this is the part where people usually exaggerate. They don't need to. The documented version is more disturbing than any exaggeration. Nazi Germany's Law for the Prevention of Genetically Diseased Offspring was passed in July 1933. German eugenic policymakers explicitly engaged with American sterilization law, including Laughlin's model statute. This relationship was acknowledged in German professional journals at the time, without embarrassment. In January 1934, a German medical journal published a detailed analysis of the new law and its debt to American precedent. At the doctor's trial in Nuremberg, beginning in 1946, defense attorneys for the accused physicians cited Buck versus Bell explicitly. Their argument? Forced sterilization for genetic reasons was not uniquely Nazi. It had been upheld by the American Supreme Court. Calling it a war crime while the same precedent stood untouched in American law would be selective prosecution. The American prosecutors pushed back, but the precedent existed, and no one came back for it afterward. Put the dates next to each other, and the story stops looking accidental. Indiana, 1907. Buck versus Bell, 1927. Germany, 1933. Harry Laughlin, honorary doctorate from Heidelberg, 1936. Nuremberg, 1946. Elaine Riddick, North Carolina, 1968. Oregon, 1981. And a 2022 National Women's Law Center report finding that 31 states and the District of Columbia still had legal pathways, in some guardianship contexts, that could permit involuntary sterilization. That is not a sequence of separate historical events. That is one continuous sentence, still unfinished. If a relative disappeared into a state institution between 1907 and the 1970s, if a record stops, if a sibling went in and came back changed in ways no one explained, there may be files. Virginia's behavioral health archives hold colony records. North Carolina has released Eugenics Board files. Oregon's records are partially accessible through the state archives. The system was meticulous. It believed it was building something permanent. The files it left behind have outlasted the consensus that created them. Carrie Buck was sterilized in October 1927, 5 months after the Supreme Court ruling. She was 21 years old. She had not been charged with a crime. She had not consented. She had not been told, in language she could understand, what the surgery would do. She married twice after leaving the colony. Late in her life, she gave one interview and said she thought the whole business had been a great mistake. But she did not dwell on it. She spoke without rage. That composure is harder to absorb than anger would be. Carrie Buck died in 1983 in a nursing home in Waynesboro, Virginia. She is buried beside her daughter Vivian at Oakwood Cemetery in Charlottesville. The grave markers give names and dates. Nothing else. And if you think this is safely buried history, the legal record says otherwise. Buck versus Bell was never expressly overturned by the Supreme Court. Skinner versus Oklahoma in 1942 introduced a constitutional right to procreation. Later, reproductive rights doctrine weakened Buck's logic further. But the court never erased the decision by name. It remains on the record, never formally repudiated. So what exactly survived when the consensus died? The 2022 NWLC report found legal pathways to involuntary sterilization still existing in guardianship frameworks across 31 states and D.C. Not broadly, not automatically, but architecturally present. The question of what those pathways permit is still being litigated. The question I am left with is not who was responsible. The documentation on that is complete. The question is what it means that a democratic society built this machine, openly, legislatively, with scientific endorsements and Supreme Court opinions. And then, when the consensus finally shifted, did not go back and dismantle the reasoning, just walked away from it. The case was decided in 11 pages. The sentence everyone remembers was 7 words long. But the system built around those 7 words outlived the people who wrote them, outlived the consensus that justified them, and in parts of American law, outlived the courage to formally erase them. Next time, the scientists who built the weapons that ended one war were given new names and new employers by another government. The agency that hired them made sure no one could ask where they came from. That case is also in the record. And that record is also still open.